right, good morning, everyone. This is the time and place scheduled for a workshop before the Nevada Gaming Control Board to discuss it and solicit comments regarding, without limitation, Nevada Gaming Commission regulations 5, 7A, and 14. Madam Secretary, if you can hear me, we don't see you, but I believe you're on audio. Are
Yes.
you there? Okay,
Yes,
wonderful.
I'm here.
Has this workshop been posted in accordance with Nevada's open meeting law?
Yes, it has.
Wonderful. Then let's proceed with our first public comment section.
Sorry,
Did
give
we
me
lose
just
you?
one moment.
Sure, take your time.
All right, this item is placed on the agenda to give the public an opportunity to comment on gaming-related matters. Anyone wishing to address the board may do so at this time. Comments by each person are limited to 3 minutes as a reasonable time, place, and manner restriction. If board members ask questions of the speaker, the time needed to address those questions will not count against the speaker's 3-minute time period. If speakers have any handouts or written copies of verbal comments to provide for the record, please hand them to the enforcement agent in the room.
Thank you, Madam Secretary. As always, we welcome any comments or discussion from the public. However, we are not able to act on anything brought up during public comment section because of Nevada's open meeting law. But again, we will welcome anybody to come up and speak, as well as anyone on the board who has anything to say during public comment. Madam Secretary, is there anyone there in Carson City wishing to make public comment this morning?
There is not.
All right, then let's go here to Las Vegas. Anyone in Las Vegas wishing to make public comment? And it doesn't have to be on the items regarding our agended matters today for possible regulatory revisions. This could be on any topic related to gaming. Seeing none, fellow board members, any public comment?
Thank you, Chairman. None by me.
None by me.
All right, then we will close our public comment. And Madam Secretary, did we receive any comments regarding these proposed regulations from the public?
We did not receive any public comments.
All right, how about any confidential comments?
We did receive one.
Okay, thank you very much. Let's go ahead and read in our first potential regulatory revision for this morning.
Our first item is the discussion and possible recommendation to the Nevada Gaming Commission of amendments to Nevada Gaming Commission Regulations 5 and 7A regarding, without limitation, the non-payment of winnings to individuals formerly trespassed from a gaming establishment or to individuals who have been placed on Nevada's list of excluded persons.
Senior Deputy Attorney General Somps, will you be presenting these potential regulatory revisions this morning?
Yes, Mr. Chairman, and just to confirm, can you hear me?
We can hear you just fine. Please proceed whenever you're ready.
All right, great. Mr. Chairman, board members, Madam Secretary, I'm Mike Somps with the Attorney General's Office, and I'm here today to present the proposed changes to Regs 5 and 7A. The proposed changes to Reg 5 is a new section 5.095, and that's contained in a draft dated September 5th of 2024, and then accompanying that are some proposed changes to Reg 7A, the patron dispute chapter, and that's contained in a draft dated September 4th, 2024. I'll note that I believe that these were made public back on September 11th, along with the public notice of this workshop, so they have been available for almost 2 weeks. The purpose of these proposed changes is to address the payment of winning wagers to individuals who have been trespassed or who are on Nevada's list of excluded persons. Before I get into the reg changes, I'll just give a really brief background to get us all up to speed. As the board might recall, and as those in the audience who are there might recall, a workshop was held last October regarding enforcement division related matters. And at that time, there was a discussion that came up regarding the issue of paying winnings to individuals who had been trespassed. The board's enforcement division over the years, for a number of years, has had a policy of requiring licensees to pay winning wagers to individuals who had previously been trespassed. At that workshop, concerns were expressed by some industry representatives with that policy, and that trespassers should not be paid winnings given that they are on the property or on the premises illegally. So following that October workshop, I was assigned to work with Chief Torgerson and the enforcement division to craft a regulation that essentially precludes licensed gaming establishments from knowingly paying winnings to individuals who had previously been trespassed. And with that, it made sense to include in such a prohibition individuals who are also on Nevada's list of excluded persons. So with that background in mind, Mr. Chairman, I can go through the language changes at this time if you'd like.
Yes, please, that'd be helpful. Thank you.
Okay, so starting with subsection 1, that is the subsection that's going to prohibit a licensed gaming establishment from knowingly paying any ostensible winnings to an individual who has previously trespassed pursuant to NRS 207-200-2E, unless that trespass warning is rescinded, or to any individual who has been placed on Nevada's list of excluded persons. Subsection 2 requires a licensed gaming establishment who issues a trespass warning to an individual to further inform the individual at that time that they're trespassed that they won't be paid any future winnings and they are not going to be reimbursed any losses, and they're not going to be deemed a patron for purposes of the patron dispute process. Subsection 3 requires a licensed gaming establishment to return the wager to any individual who has not paid winnings pursuant to subsection 1. Subsection 4 sets forth how a trespass warning is rescinded that will create some uniformity and any uncertainties that might occur as to how a trespass warning is rescinded. Subsections 5 and 6, they are a notice requirement. They require a gaming establishment to post written notice at its entrances, on its website, and in its house rules regarding the non-payment of winnings to these individuals. For individuals who have been trespassed or who are on the list of excluded persons, subsection 7 is going to require licensed gaming establishments to remove those individuals' names from direct marketing and direct mailing lists, and to disable any player award or wagering accounts for the individuals. I do want to note with this particular subsection that a future draft is going to have to contain a correction and add the word "and" after paragraph A and before paragraph B. Subsection 8 sets forth the information that must be maintained and provided to the board by a licensed gaming establishment that trespasses an individual. Subsection 9 is designed to prevent an individual who has been trespassed or who is on the list of excluded persons to use certain provisions of Reg 5.095 to argue that they're entitled to payment of winnings or get losses reimbursed because the licensee is out of compliance. So for example, if the licensee failed to post a notice at one of its entrances, the individual wouldn't be able to use that as a rationale for arguing that they should be paid winnings. Tied into that, however, is subsection 10 that will make it an unsuitable method of operation to not comply with the provisions of Reg 5.095. And then we have subsection 11 that explicitly removes individuals who fall within subsection 1 from the patron dispute process. Tied into that, we move to the changes to Regulation 7A, where we have the definition of patron amended in 7.015 sub 1 to explicitly state that an individual falling within Reg 5.0951 is not considered a patron. And so just to highlight that, the consequences if these particular provisions are adopted is that the patron dispute process is not going to be available for these individuals who are trespassed or on the list of excluded persons, and the gaming establishment doesn't pay them winnings. Their remedy, to the extent they have a remedy at all, would be through a civil court process. That is essentially all of the regulation changes. The other thing I'll note for the record, I believe that the Nevada Resort Association may have some comments on these proposed regulation changes. Other than that, I'm happy to answer any questions that you may have. Thank you.
Thank you, Senior Deputy Somps. Very succinctly put, and thank you for walking us through the proposed revisions. Let me start by going to the public first. If there's anyone here from the public who wishes to provide comment, either here or in Carson City, please go ahead and step up to the microphone now. After that, we'll take comments from my fellow board members. Let's start in Carson City. Madam Secretary, anyone in Carson City wishing to make public comment?
There is not.
Okay, thank you. We're at a bit of a disadvantage. We can hear you, but we can't see you. So if anybody does decide to come up, if there's someone there, please let us know. Here in Las Vegas, anyone who wishes to provide any input on potential revisions to Regulation 5.095 or Regulation 7? All right, seeing none, let's go to my fellow board members. Dr. Watkins, did you have any comments?
Yes, I do. With respect to what Mr. Somps just presented, and also with respect to Section 9, it provides that even if notice is not proper or it's not grounds to claim winnings or losses, but can the patron report the failed compliance to the board?
Certainly, I don't see, there's nothing in this proposed regulation change that would prevent that from occurring.
Okay, so I just wanted to clarify, because you did mention that their remedy is in the civil court process, but they can also report the unsuitable method of operation to the board for potential disciplinary action, right?
Absolutely.
Okay, thank you for clarifying that. And then with respect to, I just wanted to clarify, I'm not sure which section it is, but basically, okay, it's Section 3. It's 5.095, Section 3. And it says that a licensed gaming establishment shall return the wager to any individual who is not paid pursuant to subsection 1 of this section, but also a patron or they wouldn't fit the definition of patron under this change, but a potential patron cannot be paid losses. So you're distinguishing between those kind of payments. Can you clarify that they are entitled to the return of their wager? Is that correct? But not to any losses.
That's correct. This particular subsection is designed to basically put the parties back at square one. So the winnings won't be paid, but the wager that led to the winnings or the ostensible winnings would be returned to the patron.
Okay, thank you for clarifying that as well. That's all I have right now, Chair.
Thank you. Judge Assad, comment?
Yes. Thank you, Chairman Hendricks. Just like to commend Deputy Attorney General Somps, Senior DAG Somps, for doing a great job. A lot of work went into this, and I do appreciate it, along with the assistance from Chief Torgerson and staff. It's a very good regulation that we're passing, and especially for Ms. Augusta Massey, who's the hearing officer. The section that describes this as not being able to implement a patron dispute is critical. She's overworked, and this would greatly relieve some of the work that comes her way. So, and the industry, Dick Tomaso and the rest of the folks in the industry who pushed this through. I just want to commend you all and thank you and appreciate your work on this.
Thank you, Judge, and you took a little bit of my thunder there. I also want to thank everyone in the industry who have brought this issue to us, all of the security directors, people involved in security in the industry, and I know we've talked about this several times, so thank you all for your patience and cooperation in helping with us, and also to Hearing Examiner Massey and Hearing Examiner party up north, as well as hearing examiner Ross on a part-time basis. I need to stress how much our hearing examiners are overworked. The amount of appeals going on, the amount of gaming patron disputes going on is more than we can handle. And so it may be something we need to deal with the legislature, but in the meantime, this process that is a trespassing situation at licensees cannot end up creating more work for the Gaming Control Board. We simply don't have the staff to handle it. If a trespasser was to claim factual scenarios on how they were trespassed or how they were noticed, that is an issue between the property and the trespasser or alleged trespasser. If the matter becomes a true patron dispute, that would be something different. If it becomes a disciplinary issue, that would be something different. But if it's truly another chance to present something to the board and create more cases, we absolutely don't have the staff at the current time to handle more appeals of patron disputes. So that part is important to me. The exact language, I'm willing to hear from anybody if they think there's another way around it, but we just can't keep increasing our current caseload. I also had a couple of questions regarding the notice. Senior Deputy Somps, I see Section 5 says, every licensed gaming establishment shall conspicuously display at each public entrance. That I haven't gone out and done a study of the licensed properties, but I know there's a lot of signage already at a lot of entrances. So I would be interested in whether or not maybe that's too large to do, too burdensome. You can't end up putting an entire treatise on every post at every entrance and every entrance of a gaming licensed property. So that I'm going to be interested in maybe some future discussion on. Perhaps it's too broad. Perhaps it doesn't need to be at the entrances if we do make it available on other notice type of provisions. I'd also say I doubt that trespassers take the time to stop and read the signs before they sneak into a property, so I don't know if it's necessary. The other question I had was Section 10. Failure of a licensed gaming establishment to comply with this section is an unsuitable method of operation. That may be a little bit broad. There may be a chance for us to tighten that up as to what is an unsuitable method of operation as opposed to the entire section. And what I'm more interested in is, I believe, a little bit about what Dr. Watkins touched on. You wouldn't want somebody to come into a property and play for several hours and then finally hit a level jackpot where they have a W2G, and then the property say, well, I know you've been here for a couple hours, but now you have to go. Here's your wager back, but you can't win. That would be more factually oriented to me. I'm not claiming at all that that's happening in the industry. My guess is all security personnel, when you see somebody who's a trespasser, and they come back and they try to sneak onto a property, my guess is security is trying to get them out as soon as possible. But I think I've mentioned this in one of our earlier workshops, was we need to be sure Nevada is looked at as fair to both sides, fair to the licensee, fair to the patron. Even in this situation where they're a trespassee, we can't tip the scale to say that we'll let you be a loser, but we won't let you be a winner. Again, I'm not claiming that anybody in the industry is doing that. Just want to be clear that if there was a disciplinary matter, it would be more than just violating the section. Let's go back to the part about you didn't post a sign properly, you didn't put something on your website properly. I don't think that's what that's talking about. So, Mr. Somps, we may need to look at that section again as well. And then I do note that you stated on the record that there may be others who do want to provide input. We posted this a week and a half or so ago, but it's been worked on for longer. I am absolutely in a position of wanting to be sure that every interested party has a right to provide input on this before we vote and move this toward the commission. Yes, please.
Chair Hendrick, if you don't mind, I just had one additional question.
Please.
Mr. Somps, you may have covered this, although I did not hear it explicitly. Would a patron still be able to how would this trespass act affect a patron's ability to go to affiliated properties, to enter into affiliated properties?
I might need some help on this, but I think it depends on how the trespass warning was issued, whether it's issued for the individual property or for the individual property and its affiliates, would probably be relevant in answering that question.
Is there anyone here from the industry who can give us some real world nuts and bolts on that? If somebody's trespassed from a property that has affiliated properties, does your trespass apply across all properties, or is it a case-by-case basis, or does nobody want to jump into that pit? But please, step up. Good morning. Yeah. Please have a seat, introduce yourself, push that little button to your right there, introduce yourself for the record.
Sure. Doran Arungare, I'm with Circa Resorts. I'm the Regulatory Compliance and Licensing Manager. So with the process that we have with a master barred patron list for patrons who refuse to sign a W-9 or provide ID after going over the $10,000 limit, we have a master barred patron list, which we carry throughout the 3 casinos that were affiliated with the D, Golden Gate, and Circa.
Would that apply for other type of trespassing incidents, more just your casual, every Saturday night type of situation where somebody's asked to leave?
So it would depend on what the situation may be. If it was something where they were maybe had a little bit too much to drink, sure, we'll escort. If it escalates a little bit more, then it would become where we would trespass them permanently.
On that type of trespass, would they be trespassed from all the properties as well?
That I'd have to get a little bit more information from our
But the major
security.
ones?
But yes, the major ones, yes.
Yeah.
Which
all
would
properties.
include the.
Okay, good. Thank you. That's helpful.
Great, thanks. You know, I did have one follow-up question
Please.
to Dr. So getting back to the proposed reg, if a patron were to, or trespass patron were to, let's say, put in X amount of money, hit a jackpot, we talked about going back to square level one, would we refund the trespass patron what was coined in, or how would that work? And is that something that we have to go back to our records and see how much the patron played over the course of, like you said before, a few hours?
Mr. Soms, I think you've thought about this question before, and I don't want to put you on the spot, but if you could answer that, please feel free. Otherwise, I'll take a shot at it.
Yeah, I guess my comment to that question is that this regulation is only meant to address the wager that results in the winning. So everything before that, this particular regulation change would not address. You know, I guess it would be your standard operating procedure.
Okay, so a max bet that resulted in the W2G would just refund of the max bet, whatever the max bet was.
Yeah, that's my understanding, the way this is drafted as well, because to your point, it becomes too factually oriented of different properties and different machines, different table games. There's too many different ways of figuring out, could you go back? So the way this is drafted is, you know, that once you trespass them again or caught them being on your trespass, being a trespass person on your property, that wager needs to go back to them. But prior to that, it's probably too difficult to figure out.
Sure. Okay, great.
Thank you.
Thank you.
Anything else, Dr. Watkins?
Nothing further from me. Thank you, Chair.
Yeah, and to your point, that may be property specific, so maybe something we need more input on. But to my earlier comment, we absolutely want to be sure that all interested parties have the opportunity to provide input on this matter. Personally, I'm still a little bit befuddled on why a trespass person who was told, you shouldn't be at this property, we don't want you on this property, we're going to throw you off of this property. I'm still confused as to why they would come back on, or in certain times sneak back on that property. I know it happens, I just don't understand why it happens. So I'll put this out there. Any trespasser who plans on sneaking back onto a licensed gaming establishment, if we have another hearing, please show up. I would love to hear your thought process on why you don't go somewhere else. And if you have an attorney and they can explain it to me legally, I'm interested in that as well. I truly want to hear from all interested parties, and trespassers are a very interested party in this particular regulation. So I'll throw that out there and welcome any of you to show up next time. Based on the fact that I had a couple comments, nothing to do with the Attorney General's office, nothing to do with enforcement, just this came up, and as I was reading over it over the last week or so since it's been posted, caused me to have some more questions about wording and some specific facts, as well as I know from Senior Deputy Somps that there may be others to provide input. What I think we should do, unless anybody in the public wants to make further comment, or anybody else on the board who wants to make further comment, what I think we should do is not take action on this. And then what we will do is, if there's language that needs to be tweaked, my guess is we'll put this on a board agenda rather than a workshop agenda. And if everything works out at that point, then we'll go ahead and vote, make a recommendation to the commission.
Yes, I agree, Chair. I support that decision to put it on a board agenda, given this has been put out there in the public, and it could potentially change policy that's been in place for a very long period of time and require casinos to make changes to the postings placed on their buildings. And as you indicated earlier, that might be a lot of changes. I think waiting to hear back from the industry is a good move. So I'm hoping to hear more from the industry about this specific language and these specific changes as it relates to trespassers.
Great. All right, then I will take no action on this item. And yes, please step forward. Good morning. Have a seat. Touch that little button to your right.
For the record, my name is Dick Tomaso from Mesquite Gaming. Chairman Hendrick, Doctor, Your Honor, I just wanted to briefly say that I appear here before you to express my sincere thanks to each of you, the Deputy Attorney General, your legal team, and to Christy Torgerson for all of the time, work, and effort you expended to help your licensees address this trespass issue. I say that from the bottom of my heart. Everything that you have done, all of you have done, it's unprecedented. It really is. I find it unprecedented what you have gone through for your licensees. And for this, your licensees are extremely grateful. The vast majority of your licensees are in favor of this amendment, but have some reservations with respect to the wording of the amendment, as you so noted. Moving forward, I hope that you will continue to keep an open mind and allow the industry to present you a slightly reworded version of this amendment for your thoughtful consideration. Thank you. Thank you very much.
Thank you, Mr. Tomaso. And again, thank you for all the time and efforts you put into this and working with enforcement and all of us to see if we can move this forward to be fair to everybody.
Thank you.
Appreciate you being here.
Thank you.
All right, then. So we will take no action on this particular item and move to our next item, Madam Secretary, if you'd like to read that into the record.
Our next item is the discussion and possible recommendation to the Nevada Gaming Commission of amendments to Nevada Gaming Commission Regulation 14.
Good morning, Senior Deputy McGaw. How are you?
I'm doing well. Thank you, Mr. Chair.
Good. Will you be presenting this one for us this morning?
Yes, I will.
All right. Please proceed. Thank you.
All right. Good morning, Mr. Chair, members of the board, Madam Secretary. For the record, I'm Ed McGaw with the Nevada Attorney General's Office, here today to present the proposed regulation amendment to NGC Regulation 14.025, presented in a draft dated September 10, 2024. The proposed amendment modifies the process by which licensees or other persons can request a determination by the board chair as to the appropriateness of the themes they wish to use in connection with gaming devices. Currently, only those licensees or other persons who actually hold the intellectual rights to a theme may apply for that determination. The proposed amendment would expand the ability to seek such a determination to those who have a good faith intention to obtain such rights within a 6-month period of the request. Should the board vote to recommend the proposed amendment, it would become effective upon adoption by the Nevada Gaming Commission. With that, I conclude my affirmative presentation. I'd be happy to answer any questions the board members may have regarding the draft. In addition, Chief Deputy John Lestuski is here from the board's technology division to answer any substantive questions you may have. Thank you.
Thank you, Mr. McGaw. And this is probably something that I may have started several months ago. What happens when licensees submit a particular theme to the board and to the technology division is a lot of times they don't own the intellectual property rights, hold the intellectual property rights, and that makes perfect sense in the business world because you don't want to put the cart in front of the horse and go spend the money to obtain the intellectual property rights when you may not know if the Nevada Gaming Control Board is going to allow you to present that actual theme to the public. So this is actually, as you noted, more of a semantics and a real-world cleanup, which goes along with Governor Lombardo's request to all agencies in Nevada to streamline, clean up, fix language that just doesn't work in the real world. We don't want licensees to saying, well, I don't hold these rights, so I don't know if I can present this. And so this language will allow them to say, I have a good faith intention that I will be acquiring these rights. And Mr. Lestuski, if there's anything you'd like to add regarding this change, now would be the time.
Good morning, Chair and members of the board. John Lestuski with the Technology Division. I think you hit the nail on the head. This is just something that makes it easier for the industry to do business here in Nevada. Under the current language, you would need to obtain the rights to the IP before you could seek the determination. Now, obviously, you may not want to enter into, let's say, a 7-figure licensing agreement without some degree of certainty that you can use that intellectual property here in Nevada. So this language will allow the industry, should they have a good faith intention to acquire that intellectual property, to get that determination before they go out and make that investment. And just historically, I believe when this language was first discussed, when this regulation first went into effect, it was envisioned that the IP holders would primarily be the ones seeking the determination, and then they could then use that determination to market licensing opportunities for the intellectual property. Historically, it's predominantly been the manufacturers that have come to us seeking the determinations. And this regulation change will just make it easier for those licensees and manufacturers to go through that process.
Thank you for that historical clarification. Yeah, the 3 words there, or other person, would make sense. You don't have to be a licensee to present this to the board for approval, and you could actually be the intellectual property holder and then go shop it to the manufacturer. So that's a good point. Now, by this revision, I am not begging the public to come flood us with a whole bunch of, I may have a chance to get a certain property. My guess is that if you don't hold the rights to the NFL, you probably do not have the right to come to us and tell us you may have the rights to the NFL. The chances of some non-manufacturer just having a chance at the NFL, the NBA rights, is highly remote. So if people just start flooding us with, I may have a chance to get the rights to the NBA, those are probably going to be summarily denied unless you can prove to us in good faith, in writing, that you actually potentially can do so.
Yeah, I think it's important to have a qualifier there. We already get a flood of inquiries from people across the spectrum, many of whom are not in the industry, that they've got the latest and greatest idea that they want to bring here.
Absolutely. We're not looking for everybody to just start submitting proposals. That's not what this means, but it does clarify for anybody who does hold the rights, or for a manufacturer or other licensee, that you don't have to acquire them, to your point. So that's the intention of this proposed revision. Let me open it up to the public. Is there anyone here in the public in Las Vegas who has comment about this proposed revision? Seeing none, let's go to Carson City. Madam Secretary, anybody in Carson City wishing to make comment on this proposed revision?
There is not.
We can now see a few of the chairs, and I don't see anybody run into the podium. Good. Fellow board members, questions or comments about this proposed revision?
Yes, Chair, just a comment. I would just say that I'm in support of the revision. I think it's important to expand the right to request a determination for the reasons Mr. Listowski identified. You want to be sure that you're going to get a return on your investment. But I also think it's important to limit that right to request so that the board isn't overwhelmed with these requests. And I think it's appropriate to base that limitation on a good faith intention to acquire within a 6-month time period, and that request must come in writing. So I'm in support of this change.
Thank you. Judge Assad?
Yes, thank you, Chairman Hendricks. I'm in support of the amendment.
I would say the only other thing is down the road, if there are a lot of requests that people are making good faith intentioned applications, that there may be, if without enough support, we may need to look at some stronger language that we didn't talk about under oath or anything like that, because I don't think it's necessary. I think the people you're going to see in the technology division either have those rights, or they're the ones who believe they're going to be able to acquire those rights. Down the road, that may need some tweaking, but first of all, let me say, as the chair who reviews these, thank you to the technology division for all you do before they get to my point. I know a lot of the times, by the time I've seen them, the technology division has gone back and forth multiple times to say, even if you do own the IP rights, you're going to need to tweak this, or my guess is this may not be approved by the chair, may not be approved in Nevada. And so all of that is extremely helpful. Your understanding of Nevada's public policy goals and where this has transformed over the last 10 or 20 years from used to be kiddie themes, and now it's a lot of themes. And so appreciate all the work that you do on a daily basis to help the state of Nevada. Again, as the governor said, we want to put product out that the public wants, and we want to move it out to the floor as quickly as possible, but it has to be within Nevada's public policy goals. So appreciate all your help on that. Senior Deputy McGaw, anything else you'd like to add?
No, Mr. Chair.
All right, then if one of my fellow board members would like to make a motion on this particular item, now would be the time.
I'll make a motion, Chair.
Please.
I move to recommend the proposed amendment to NGC Regulation 14.025 as presented in the draft dated September 10th, 2024 for adoption by the Nevada Gaming Commission to be effective upon adoption.
Thank you. Madam Secretary.
Member Assad?
Aye.
Member Watkins?
Aye.
Chairman Hendrick?
Aye, that motion passes, and we'll go to the commission in the proper timing that is required. Thank you, Senior Deputy McGaw.
Thank you.
All right, Madam Secretary, I think that was all of our proposed revision recommendations today. As our last item, public comment again?
It is.
All right, please read that into the record.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters. Anyone wishing to address the board may do so at this time. Comments by each person are limited to 3 minutes as a reasonable time, place, and manner restriction. If board members ask questions of the speaker, the time needed to address those questions will not count against the speaker's 3-minute time period. If speakers have any handouts or written copies of verbal comments to provide for the record, please hand them to the enforcement agent in the room.
Thank you, Madam Secretary. Let's start in Carson City. Anyone in Carson City wishing to make public comment? Seeing none, let's go here to Las Vegas. Anyone in Las Vegas wishing to make public comment? Fellow board members, any public comment?
Nothing for me, Chair.
Good.
All right, then thank you to everyone who appeared in person today. We appreciate your interest and your time for showing up. And thank you to everyone also joining us virtually today. This will conclude our workshop for September 24th, 2024. Thank you all.